The nuts and bolts of a workers' compensation claim in Maryland are as follows, and it's a very complicated area of law, so try to follow along the best you can, but that's the main reason you're hiring a lawyer, so you don't have to remember all this and you don't have to understand every little bit of it. There are several different types of compensation available to you. Number one, and the most important thing to try to get you back on your feet right away, is what we call TT. It's temporary total disability pay. You'd be entitled to 2/3 of your average weekly wage. Unfortunately, under Maryland law in most states, you're never paid, you're never completely reimbursed the full amount of your wages. You're reimbursed for 2/3 of your average weekly wage. The second component, equally important, is paying your medical expenses. The workers' compensation insurance company is absolutely obligated under Maryland law to pay all your past medical expenses and all your future medical expenses as a result of your accident at work. That would include surgeries, physical therapies, follow-up appointments, prescriptions, even your mileage to and from a doctor are covered. So that is obviously an important component as well. The third component, after you have recovered and reached the magic term of what we call maximum medical improvement, if we can demonstrate through a doctor that you have a permanent disability as a result of the accident, let's say you have a compound fracture of your arm and you have long-term medical complications from that, and your arm is only ever going to be 80% as good as it was before, then we have a right to file for what's called a permanency award. And a permanency award pays you for a percentage of the loss of industrial function of that appendage or that part of your body. So we would have those three components: the lost wages, the medical expenses, and then if there were a long-term disability, we have a right to file for a permanency award, and that would usually require going to a hearing at a workers' compensation hearing in front of a workers' compensation commissioner. It's important to remember that when you have a claim in Maryland and you have an injury at work, you have 2 years from the date of the injury to file a workers' compensation claim with the Workers' Compensation Commission. A lot of employers will make a claim with their insurance company and tell the employee, hey, we filed a claim on your behalf, but they've only filed a claim with their insurance company and not with the Workers' Compensation Commission. That can be very misleading. Clients come to me all the time who've been injured at work and they say, my employer already filed a claim for me. And that's not true. They filed a claim with their own insurance company. To protect your rights, we need to file a claim with the Workers' Compensation Commission as well. That 2-year limitation can be waived, but typically you're only safe if it's filed within that 2-year time period. If you file a claim within that 2-year time period and you go through the claims process, the employer is theoretically obligated for the rest of your life to pay for medical treatment to that injury. The most important thing you can do when you're injured at work is, number one, obviously take care of the injury, whether that involves calling 911 or going to the hospital on your own. But equally as important as that is taking care of your body, you've got to notify someone. The worst thing you can do is get hurt at work, keep it to yourself, go to the hospital the next day and say, hey, I hurt my back at work. You call your boss the next day, he's going to say, you looked fine when you left yesterday, and you might have a dispute as to that claim. There are cases where people get hurt outside of work and make frivolous claims, so it's very important to document the injury at work some way. So if you're alone, you need to notify your supervisor or a coworker, hey, I just hurt my back, or hey, I just twisted my neck really badly. I think I need to go to the doctor. That is absolutely crucial because that eliminates the possibility that they might later dispute that the injury happened at work in the course of your employment, which is a statutory requirement in order to effectuate a claim. If you're injured at work and you file a workers' compensation claim, there are employers, particularly the smaller the employer, the more this tends to be the case, that get upset because it may affect their workers' compensation insurance rates down the line. I have seen cases where people are retaliated against. If they're offered light duty, they get the worst job in the place, and sometimes they are fired. You may have a separate cause of action against the employer for wrongful termination, but it really wouldn't affect the workers' compensation claim. But yes, there are cases where employers do the wrong thing and fire people when they've been injured at work, or they deny that it happened at work, or they say the person's faking or malingering in some way. There's a lot of bad things that employers do to people, which absolutely accentuates the point that you have to have a lawyer to go through this process. If you're injured at work and you work for a small company or even a large company, and the company does not have an active workers' compensation insurance policy, there is an uninsured workers fund administered through the state that we would have the option of making a claim with them. Over the course of my career, I've handled every kind of workers' compensation injury you can think of, literally from head to toe. Any injury that happens at work is theoretically compensable as long as, again, we go through those statutory requirements. We can demonstrate there's an injury, and we can demonstrate any permanency down the road. So there's no injury that I'm not equipped to handle. In the course of my career, I've handled fatalities at work, which are compensable, and those are important too because the statutory scheme that's set up takes care of the widow, it takes care of children, it provides compensation for death benefits, funeral expenses. So that's a very important claim and has to be handled very competently. Slip and falls at work are very, very common. Car accidents in the course of your employment. Now, there's a coming and going rule. If you get in your car at your house and drive to work and you're injured on your way to work or your way home from work, that's not compensable. Now, if you're running a special errand for your employer, if I tell my secretary, hey, I need you to run to Office Depot and get me a case of paper, well, she's in the course of her employment even though she's not on the premises. So that would be an example of a compensable injury. Back and neck injuries are an important component, especially Maryland, or Baltimore particularly, is a blue-collar town. There's lots of blue-collar workers here, and they're guys that work hard every day, and sometimes their bodies wear out. They get hurt, they twist their back, they twist their neck, and they're entitled to compensation. These guys, have been busting their hump for a long time for the same employer, and they're entitled to compensation. If you have a pre-existing injury and a new accident at work aggravates that, and that's often, again, the case in some of these guys that work blue-collar, heavy lifting type jobs, what the commission does is it apportions a percentage of disability to the old accident, and it would apportion a percentage of disability to the new accident, and then the award is based on that apportionment of the new accident. Under Maryland workers' comp law, if you do have a pre-existing condition, you would be covered as long as we can demonstrate, and certainly that's done through medical records and medical evaluations and your own testimony. We have to establish, however, that the new injury, A, happened at work and in the course of employment, and B, aggravated that old injury, and there's some independent causation from the new injury. If your employer tries to change your status, whether that's firing you or making you an independent contractor after the fact, what controls is what you were, what your status was when the injury occurred. They can't rewrite history. Do not attempt to navigate the legal system alone. Contact the law offices of John Grayson Turnbull III at 410-321-8860 to discuss your rights and how to protect them. You can also visit www.johnturnbulllaw.com.